You've eaten Pizza Hut's stuffed crust, and a family in Brooklyn patented that exact idea 8 years before Pizza Hut ever sold a slice of it, then sued for $1 billion and didn't collect a cent. Not because Pizza Hut didn't build the same product, because of one sentence their own patent lawyer wrote back in 1985.
This isn't a story about a stolen recipe, even though that's how it usually gets told. Recipes and flavors aren't something you can own in the United States. Courts have ruled that flavor performs a function, not a brand identity, so it can't be trademarked. And combinations of known ingredients are almost always too obvious to patent on their own.
So if this case wasn't about a secret formula, what was a family really suing the biggest pizza chain in the country over? And how did they walk away with nothing from a case that, on paper, looked like it should have been theirs? On one side was a small, family-run patent holder from Brooklyn. On the other was one of the biggest fast food chains in the country. That kind of matchup should have been the whole story. Start with the man who filed it. Anthony Mongello grew up in Bensonhurst, Brooklyn, in a family with 2 generations of patents behind it. His grandfather held a patent on a tapered ricotta tin. His father built and patented a machine that molded mozzarella. In 1982, while shaping pizza dough, Mongello accidentally combined 2 dough balls and ended up with extra dough sitting around the rim. Instead of trimming it off, he stuffed it with cheese. His father told him to protect the idea properly. In June 1984, Mongello and his brother Lawrence filed a patent application containing 24 separate claims covering the process. The patent examiner rejected almost all of it, comparing the design to deep dish pizza structures that already existed on record and calling the broader claims obvious. To get anything approved at all, Mongello had to narrow his language from a wide claim over stuffed crust in general down to one specific step-by-step method involving what the final patent called separated individual food portions, each one sealed into its own closed pocket. That narrower version issued on April 28, 1987, as U.S. Patent 4,661,361, a process patent covering 15 assembly steps, not a product patent covering the idea of cheese-filled crust itself. In early 1988, Mongello mailed a copy directly to Pizza Hut's corporate headquarters, offering a commercial license. Pizza Hut turned him down that May. Here's the part almost nobody includes when they tell this story. Pizza Hut wasn't hiding from that letter for the next several years. Its own internal market research had already flagged that customers routinely threw away the outer crust. Company researchers were calling it pizza bones. Solving a problem your own market data literally nicknamed garbage isn't most people's idea of a glamorous assignment. But between 1992 and 1994, a Pizza Hut food scientist named Patty Scheibmeyer led exactly that project. And the assembly method she developed didn't match Mongello's patent. It didn't use separated portions of cheese, each sealed into its own pocket. It used 5 sticks of thawed mozzarella laid end-to-end around the rim, forming one continuous ring, folded over and pressed into a single unbroken seal. Pizza Hut launched stuffed crust pizza nationwide on March 25, 1995, backed by a $45 million advertising campaign, enough spending to buy roughly 900 average American homes at the time. It drove more than $300 million in additional annual sales. Real money, even for a chain that size, and enough to make stuffed crust one of the most successful menu launches in fast food history. 7 months later, on November 8, 1995, Angelo Mongello's Children, LLC, filed suit against Pizza Hut in federal court in the Eastern District of New York, seeking damages estimated as high as $1 billion, one of the largest patent claims a single family-owned business had ever filed against a national restaurant chain. By the time the lawsuit was filed, the two sides couldn't have looked more mismatched. On one side, a small, family-run intellectual property holding company built around one Brooklyn inventor's patent. On the other, a fast food chain operating thousands of locations, backed at the time by PepsiCo's balance sheet. That kind of matchup is exactly the setup people expect to end one way. A scrappy inventor finally cashing in against a corporate giant that got caught.
This case didn't end that way, and the reason why has almost nothing to do with which side had more money or a better story. Two questions were open at that point, and they stayed open through nearly 4 years of litigation. Did Pizza Hut's product match the process Mongello had patented, word for word? And even if it looked the same on a plate, would that be enough to win in a courtroom where a plate isn't what gets examined? Somewhere in the middle of that gap sat a legal doctrine most viewers have never heard of, and it decided the entire case before either side ever mentioned the taste of the pizza. But the reason this case ended the way it did hasn't even come up yet, and it has almost nothing to do with cheese. Patent lawsuits aren't decided by comparing two pizzas side by side. They're decided by comparing the finished product to the exact wording of the patent claims, because the words of the claim are the only thing a patent legally protects. That comparison process is called claim construction, and it's where this case was won and lost. Mongello's patent required separated individual portions of food, each one sealed into its own closed pocket. Pizza Hut's own manager's guide, produced during discovery, described a continuous ring of cheese sealed with a single, unbroken press around the entire crust, not a series of individual pockets. On paper, those are two different assembly methods, even if the finished pizzas looked similar once they came out of the oven. Mongello's legal team tried to close that gap with video evidence. Footage of Anthony and his brother cutting open baked Pizza Hut pizzas and pointing to internal dough walls that occasionally split the cheese into sections. To someone with no legal background, that looks exactly like the sealed pockets described in the patent. Judge Eugene Nickerson didn't read it that way. He found that any internal dividers inside Pizza Hut's crust were the incidental result of dough shifting under high oven heat, not evidence that Pizza Hut's kitchens were deliberately performing the specific sealing steps the patent required. There's also a rule working against Mongello that has nothing to do with what Pizza Hut did in its kitchens at all. It's called prosecution history estoppel, and it means that once you narrow your patent claims to get past an examiner's rejection, you can't later go back to court and argue your patent covers the broader version you gave up to secure approval in the first place. Mongello had traded broad protection for a narrower patent that the examiner would actually approve back in 1985 and 1986. That trade is what let the invention become legally real in the first place. It's also exactly what limited how far it could reach 9 years later in a courtroom against a much larger opponent. On August 31st, 1999, Judge Nickerson ruled. Pizza Hut's motion for summary judgment of non-infringement was granted. Mongello's competing motion was denied. Summary judgment means a judge can end a case without sending it to a jury, when the underlying facts aren't seriously in dispute and one side is entitled to win as a matter of law. There was no trial, there was no negotiated settlement figure. Angelo Mongello's Children, LLC received $0 on a $1 billion claim. Anthony Mongello chose not to appeal to the federal circuit. In later interviews, he pointed to the cost of continuing to fight a company backed by PepsiCo's resources as the reason he stopped there. It's worth saying plainly, because a 2023 documentary and years of viral posts have blurred it. Nothing in the court record supports the idea that Pizza Hut copied a secret formula or lifted confidential information. Mongello's method was public the moment his patent was granted in 1987. That's the deal a patent makes with an inventor: protection in exchange for disclosure. Pizza Hut's food science team spent 2 years building its own version from scratch, working from customer complaints about wasted crust, not from Mongello's paperwork. The court record does not support the version of this story that gets repeated most often. If you've ever come up with something worth protecting, an idea, a product, a process, even a piece of software, this case is a big part of why patent attorneys tell inventors to think carefully before they file. A patent forces you to describe your invention publicly in exact technical language, and that language becomes the entire boundary of what you legally own. not the general idea behind it. Trade secret protection works the opposite way. It only survives as long as the information stays confidential, which is exactly why Mangiello couldn't fall back on it once Pizza Hut launched its own version. He'd already published his method to the world to get the patent approved in 1987. Partly because of cases like this one, food and beverage companies today lean much harder on trade secrets, internal non-disclosure agreements, and lockdown supply chains rather than public process patents, since a published patent hands competitors a blueprint for designing legally around it.
The internet still tells this one as a story about a corporation stealing a family's secret pizza recipe. The court record tells a narrower and honestly more useful story about how the exact wording inside a legal document can end up mattering more than who built something first. One side patented a specific process.
The other side built something that looked almost identical from the outside, and underneath, legally, wasn't the same thing at all. If you've got an opinion on how this one should have gone, drop it in the comments. Plenty of patent attorneys still disagree about exactly where that line should sit. If cases like this are your kind of rabbit hole, this channel exists to dig up the ones nobody else is covering. So subscribe if you don't want to miss the next one.
And next week, we're looking at a case where the government doesn't even need to charge anyone with a crime to take their money. Why your innocent passenger's cash can be legally seized from your car without any criminal charges being filed at all.